Bill. The Honourable Judith Collins made excellent comments in her introductory remarks. I absolutely commend it to the House.
Speaker.
Honourable Leanne Dalziel.
Mr. Speaker, I too rise to speak in relation to the Legal Assistance Sustainability Amendment Bill, and I, like my colleague Andrew Little, believes very strongly that this is certainly an improved bill from the one that was introduced, but not one that we can support. And I think that the comments made by the Minister, actually, I mean, she reflected on the $41.3 million over 3 years that they intend to save from the cost of legal aid in care of children cases with respect to a piece of legislation that is still before the Justice and Electoral Committee. And I just want to comment on that because everyone has so far mentioned that particular piece of legislation and talked about the impact of those savings. But when we hear government members talk about the savings in their fiscally responsible way, they never ever talk about who will carry the cost if things don't go the way that they anticipate they will. So let me just let the House know exactly what the Minister means when she says that there will be $41.3 million worth of savings. Legal aid will not be available for simple track proceedings up to and including settlement hearings and standard track proceedings. This would only apply to care of children cases. Lawyers could be engaged and privately funded. Legal aid would still be available for without notice proceedings and for standard track proceedings once they were set down for hearing. What that means, in fact, is that without any a claim of essentially abuse within the relationship or an abusive environment, there is no capacity to get lawyers involved in the early part of proceedings unless you can afford to pay for it yourself. So that creates, where you already have a disproportionate relationship between two people in terms of their capacity to afford legal assistance, that immediately puts the most vulnerable of the two, or the more vulnerable of the two, on an unequal footing yet again, where one party can obtain legal assistance that they can afford to pay for, the other cannot. The option only affects those parties who, because of their low income, are eligible for legal aid. If they cannot get legal aid, they are likely to be unrepresented, but the opposing party may have a lawyer. This is what the RIS sets out. This could lead to the represented party's view being put more strongly and create or exacerbate power imbalances between the parties. It may also lead to a perception that access to the court is the preserve of those who can afford it. Well, that's correct. That is absolutely spot on. But the advantage that they see, so they've acknowledged that that is the impact of it, but it manages legal aid expenditure, and that just does seem to be the overriding consideration. It then goes on to say that some people may have difficulty completing the forms. Proceedings may take longer, and a judge may feel he or she needs to see the parties in court more often. There is likely to be greater demand for court staff and non-governmental organisations to assist people. Better information resources, clearer court processes and use of support persons would help mitigate these disadvantages for lawyers. Legal aid work would reduce, but other work would not. I think they're missing the point. In this whole figure of 41 million assumes proceedings with the mandatory family dispute resolution option. And the whole purpose of this option is, as the Minister herself stood in this House just a few minutes ago and said, this is about getting people to sort out their private disputes away from the court and not coming near the court, and therefore saving her budget this extraordinary amount of money. But the judges don't agree that that's going to happen. And certainly the lawyers that we have heard at the Select Committee, they don't think that that's going to happen as well. In fact, what they are fearful of is that the most vulnerable of individuals who come before the courts will find themselves in an even more vulnerable situation. And they talked of people who can't read, adults who cannot read, people for whom English is a second, third, fourth language, who won't have the capacity to understand necessarily what they have to include in their affidavit. People who have intellectual disability who we know find themselves much more vulnerable to abusive environments than those who don't. Others with disabilities who, again, we've had many people give evidence in relation to that matter. We've had lawyers give us examples of cases that I think that when we do get round to debating that bill, members of this House would be moved to hear the details of them. We have heard evidence in private, which we will be able to refer to when that bill does come back to the House. And what I'm concerned about is that we have already heard two speeches from the government that reflect a mindset which is about knowing the price of everything and the value of nothing. And the examples that we've had given to us, and I'll just reflect on one lawyer who gave evidence down in Christchurch because I think it's incredibly relevant to this. She was working for a larger law firm, and of course when the legal aid changes were first mooted, that was a law firm. The entire law firm decided that it would not make itself available for legal aid cases anymore. And that law firm in Christchurch is not alone in terms of its pulling out of the legal aid work. And this particular lawyer who presented, I think, a very compelling submission to the Select Committee, she said that she couldn't desert the clients that she had. They were largely refugees, recent migrants, people with difficulty with English not being their first language, people who had some of the most vulnerable situations that they were having to confront. Now, she said that in her conscience, her ethics said to her that she could not stop providing that service to her clients. And so she left the law firm and set up on her own in a difficult situation in Christchurch. This is post-earthquake. This is with all of the stuff that's going on. She set herself up in her own practice so that she could continue to provide legal aid support to that particularly vulnerable group of clients. And I think that members of the government have to remember that when you start talking about big numbers like $41 million, you have to remember that that's actually potentially taking away the capacity for vulnerable New Zealanders to access our courts. And that's what the legal aid system is all about. And I just want to remind people of the risks that were set out in the regulatory impact statement for this bill when it was introduced. Reductions in the price paid to lawyers could create gaps in provision, particularly in the family and civil jurisdictions where there is more choice of private work and in some smaller centres where there are already supply issues. We've already seen that come to pass. The introduction of income and asset thresholds for the criminal means test will be in tension with Section 24F of the New Zealand Bill of Rights Act, providing for the right to an affordable offence. It could also delay some court cases if judges defer proceedings because of inadequate representation. Restrictions to eligibility will disadvantage people on low incomes who have few options to find legal services elsewhere. Generally, this includes young Māori men in the criminal jurisdiction and women and children in the family jurisdiction. And I do want members of the House to think about young Māori men in the criminal jurisdiction and women and children in the family jurisdiction. And then it says, withdrawing legal aid for low-income groups is likely to lead to additional costs elsewhere in the justice system, which is where I began. In particular, it may increase the number of self-represented litigants with flow-on costs due to delays, additional assistance required from court staff and the judiciary, and the higher numbers of appeals of decisions. Mr Speaker, I think this is very poor legislation. It may have improved at the Select Committee as a result of the Minister's SOP, but it is still not worthy of passage through this House.
David Clendon.
Thank you, Mr Speaker. One would be hard-pressed to say